Welcome to this explainer. Okay, today we're opening up a seriously fascinating time capsule of law and culture. We're looking at the Inheritance Act of Bhutan from 1980. And honestly, this isn't just some dry legal document, it's actually a profound and sometimes super dramatic lens into how family dynamics, loyalty, and wealth are governed in Bhutanese society. I am so thrilled to guide you through this because the way this law meticulously categorizes relationships and property is just absolutely captivating. Let's get right into it.
Picture this for a second. What if moving out of your parents' house meant you completely lost your inheritance? Like, entirely gone. In a lot of cultures, inheritance is kind of seen as a birthright, right? Doesn't matter where you live. But as we're going to see in this 1980 law, Bhutanese inheritance is deeply, deeply tied to strict rules. It's all about physical presence and unwavering family loyalty.
Okay, let's dive into this. Here's our quick roadmap for today. 1. The main house rules. 2. Leaving home and toshing. 3. The drama of divorce. 4. Writing a valid will. And 5. Who inherits what. All right, starting off with Section 1, the main house rules. So to really grasp inheritance in Bhutan under this 1980 Act, you have to understand the foundational concept of the joint family. Literally everything flows from this idea. The joint family is the core unit that holds property rights. The true members are the parents, their children, and direct descendants. But here's the catch. Membership isn't just about blood or having a marriage certificate. It's heavily dictated by a recurring theme in this law, something we're going to call the Rule of 10.
You see, time is everything in this system. If a daughter-in-law or son-in-law marries into the family, they have to physically live with that joint family for a full 10 years before they're legally recognized as a true member with inheritance rights. 10 whole years. And conversely, think about this. What if you leave the main house to take up government service? Well, if you're absent for more than 10 years without contributing financially to the main house, you completely lose your rights to the inheritance. No way around it, unless the remaining family members hold a unanimous vote, yes, unanimous, to accept you back. It's a system that absolutely rewards physical presence and tangible contribution.
Moving right along to Section 2, leaving home and toshing.
Now, separating from the main family has massive legal consequences, and this introduces a really unique concept called toshing. If a member wants to leave the main house, or maybe if a childless couple is handing over property to a relative, they might take toshing. Basically, this is a lifelong livelihood land grant. It ensures the departing member has enough land to just survive on for the rest of their life, but without actually transferring the absolute ownership of that land away from the main house. It's brilliantly designed as the ultimate safety net. But how does toshing actually compare to full inheritance? Well, if you hold toshing land, you can't sell it, you can't gift it, and you can't mortgage it without the express consent of the person who gave it to you. You're the one on the hook for the taxes, and crucially, when you pass away, the land reverts directly back to the main house. Full inheritance, on the flip side, grants absolute rights. And, oh, here's a super surprising fact straight from the text. If you leave the main house to take up a religious life as a monk and you aren't physically disabled, you are legally barred from claiming your toshing livelihood land until you turn 40. Crazy, right?
All right, Section 3, the drama of divorce. So, how exactly does this law handle the messy reality of dividing assets when a marriage ends? The very first thing the law looks at is whether the couple was a joint family. And the defining metric for this, it might actually surprise you. It's the kitchen. Yep, the kitchen. Regardless of whether you have a marriage certificate or even if you bought properties individually, if a husband and wife share a common kitchen, the law deems them a joint family. That means shared assets on divorce. But if you have separate kitchens, you are not a joint family, and properties are kept entirely separate when you split.
Now, what's really interesting here is the incredible, almost mathematical precision applied to a fault-based divorce. If it's a mutual, no-fault divorce, any acquired joint properties are just split 50-50. Simple enough. But if one party is at fault, meaning they committed a misdemeanor that led to the divorce, the innocent party gets 2/3 of the remaining properties, and the at-fault party gets only 1/3. Now, if they have kids, the pie is split into 4 parts. 2 parts, or 50%, goes to the innocent spouse. The at-fault spouse gets 25%, and the children share the remaining 25%. Oh, and a really important detail. Minor children are legally protected from carrying any of the joint family debts.
But wait, The rule of 10 strikes again. If a joint family couple divorces before reaching their 10-year anniversary, there is absolutely no sharing of properties they brought into the marriage or inherited. Zero. It's only after 10 full years of marriage that jointly acquired properties are split equally. Plus, if an innocent spouse is leaving after 10 years of marriage and is left with absolutely zero land, the law actually mandates that the other spouse must provide them with a plot of Toshing livelihood land so they can survive.
Finally, for this part, there are some debts and assets you strictly cannot split. The law is crystal clear here. If your spouse racked up gambling debts or got hit with criminal fines, you are entirely off the hook. You can't make your ex pay for your gambling losses. Those have to be settled individually. You also can't claim refunds for expenses that were purely for your ex's personal benefit during the marriage, and you absolutely cannot touch inheritances they received from their parents.
Next up, Section 4, Writing a Valid Will.
When we transition to the end of life, the procedures for passing on property become incredibly strict. A will can be either oral or written, but if it's oral, the clock is ticking. Step 1, the dying person has to make their declaration before at least 2 completely unrelated impartial witnesses. Step 2, those witnesses must drop a written document based on what was said. And Step 3, this is absolutely vital. This written declaration must be completed within 30 days of the oral statement. If day 31 hits and there's a dispute, the court renders that oral will completely invalid. The deathbed wishes are just voided.
The law also sets up a super clear hierarchy to prevent any confusion. Basically, a written will always take precedence over an oral one. If there are multiple written wills floating around, the one officially kept in court is the winner. If none are in court, the most recent one wins. And here's an interesting little caveat. If the person making the will was illiterate, the will is still perfectly valid even if someone else acted as a scriptwriter, as long as 2 unrelated witnesses sign and stamp it.
Which brings us to our final act, Section 5. Who inherits what?
Now we get to the really dramatic exclusions in the Act. You want to know how to get entirely cut out? You are completely and utterly disinherited if you renounce your Bhutanese citizenship or abscond from the country. Even more intensely, if you are convicted of treason against the country, not only do you lose your share, but your innocent spouse and children are completely cut off from your portion too. Also, non-Bhutanese citizens married to Bhutanese citizens are legally restricted to only getting movable properties. They literally cannot inherit immovable property like land or houses.
But perhaps the most fascinating rule of the whole shebang acts as a strict wealth cap. Get this. The law states that if an heir is already wealthy, which is specifically defined as owning 25 acres of land or getting a yield of 16,000 measures from their fields twice a year, they are legally barred from taking any more land from the deceased. Essentially, the law is actively stepping in to prevent the extreme concentration of land ownership within a single family.
So, as we wrap up this explainer, I want to leave you with a provocative thought. How does encoding family loyalty, kitchen habits, and strict timelines into law shape a culture's entire view of inheritance? The 1980 Inheritance Act of Bhutan intertwines some pretty intense family drama with rigid, mathematical law. It really goes to show that inheritance isn't just about what you leave behind, right? It's deeply, deeply tied to how you lived, who you shared a kitchen with, and exactly how long you stayed loyal to the main house. I really hope this deep dive sparked your curiosity to explore more cultural legal codes out there. Thanks so much for learning with me today.